No, God, I hope not.
I got some flurries outside my window, and April
No,
15th, we're seeing flurries. That's
don't
unbelievable.
say that.
I'm telling you, you don't have to hope. I'm looking up my window in Vaughan and I see it snowing. So, I mean, that's pretty crazy.
That is crazy. It was rain. I was in court today and it was like raining, and I was like,
Mhm.
oh my God. It
Amazing.
is 5 o'clock and we are live. So I'm gonna get us started.
Let's do it.
Welcome everyone. Oh, it's 5:01. Oh no. Okay, welcome everyone to Family Law Now After Hours. Today it's me and Joe, and we are talking about addressing false allegations made by your ex. Please note that the purpose of this series is to discuss general information on separation, divorce, and family law matters. Any information provided today should not be considered as legal advice. Please feel free to use the Q&A feature to submit any questions and comments. If you do have questions regarding your specific matter, please call our office or a lawyer in your area to book a consultation to receive tailored advice. Also stay tuned because towards the end, we will be sharing how you can schedule a free initial consultation of up to 20 minutes with one of our lawyers. I will move on to our bios. Today, we do have Joseph joining us. Joe is a compassionate family lawyer driven by a deep desire to support families through challenging times. With a background in commerce, he brings strong negotiation, analytical, and critical thinking skills to his legal practice. During his articling period, he gained confidence in handling a wide range of family law matters. Joseph emphasizes active listening, clear communication, and empathy, fostering a comfortable environment for clients. He is certified as a collaborative lawyer with the Ontario Association of Collaborative Professionals and offers clients an alternative dispute resolution approach to avoid court. Joining Joe is myself. I am a dedicated family lawyer with a strong focus on compassionate and effective legal representation. I have a background in business management, which enhances my strategic approach to legal matters. I excel in negotiation, achieving favorable settlements through strategic dialogue and strong advocacy for my clients. I prioritize clear communication, ensuring that clients are informed and empowered throughout the legal process. Joe, can you get us started today? Let's jump right into our topic. Let's
Let's do
say
it.
Let's say we have a Jane Doe and she's going through a family matter. She's going through a
Mhm.
separation and she's facing false allegations. So what's
Mhm.
the first thing you tell her?
Yeah, so I think it's really important to note that I know you said Jane Doe instead of John Doe, and I mean we see it both ways, whether or not we're representing, a male client versus a female client. These types of allegations, they stem both ways. So it's not really one-sided. And we do see it more often than not with both, men and women. It's not one gendered. But anyways, as soon as they come into the office, first thing I tell them is that we need to prioritize remaining calm and being strategic on how we're going to proceed moving forward, right? I always tell clients that your reaction matters. It's really important that they stay level-headed, even when they've been falsely accused of something, whether that's related to criminal charges, whether that's in relation to anything dealing with the Family Responsibility Office, maybe that they're in arrears, maybe it deals with claims made to Children's Aid Society. There's a lot of ways in which an individual can be falsely accused of something. So it's really important that even in light of these accusations, that you remain level-headed. Um, it's really important to focus on emotional control, right? Obviously, false allegations, they're upsetting. They can trigger anger, fear, shame, especially if they're broadcasted on a public level. So the emotional outbursts that clients have, right? Especially if they're documented, whether that's in text messages, whether that's publicly on a social media forum, these types of outbursts can be used against you, um, either in court. or sometimes they can have a great influence with third party perceptions. And again, that's more along the lines of whether or not, again, CAS is involved and there's child protection workers involved in front of a judge. So we want to limit any negative influence from third parties, especially those that typically have a great say in the outcome of decision making, or at least influence the judge in their decision making process. So it's really important for clients to avoid immediate retaliation. I know in the moment it seems that an immediate response is necessary, but more often than not, it's not really necessarily the case. Um, Clients should not be sending angry texts. They should not be posting on social media. They should not even be confronting their ex-spouse directly. More often than not, doing so escalates the situation, which we never want. And we also don't want to convey the notion that they may be actually supporting the narrative being put forward. So I always tell clients, take 24 hours, think about what's been done, because in the heat of the moment, you want to be quick to respond. And this isn't even just at the onset of litigation or the onset of being retained. It can even be throughout the process itself. Maybe we might have already had a case conference. Maybe we've already had a couple months of going back and forth with negotiating separation agreements. But I always tell clients, avoid the immediate retaliation. Give it 24 hours. Let cooler heads prevail, and that we can discuss a plan of attack. Um, what I tell clients to do during that process, especially the 24 hours immediately after being maybe fed this news or getting light of the accusation. I tell clients that they should be documenting their thoughts. And again, they shouldn't be documenting their thoughts to their ex. They shouldn't be doing it through text message. They shouldn't be doing it through social media, but rather they should be doing it privately. So instead of reacting impulsively, I always tell them to take a minute, sit down, have a journal. It can be on their computer, it can be on their notes page, and they should be privately documenting what they're experiencing. One, it really helps, express yourself in a safe environment, and it also allows your legal team. The lawyer involved, maybe we're going to be communicating to the children protection worker in the future regarding this accusation. Sit down, document how you're feeling, why you believe the accusation is false, and rather than again sharing that with your ex who's initiating that accusation, share it with us, share it with your legal team. And you have a long period of time, like I said, usually about 24 to 48 hours to really think about your response. And again, it goes back to avoiding that immediate retaliation. And finally, I always like to preface that strategy works better than reaction, right? It's really important that clients treat every decision that they make as part of a long-term strategy, and not a short-term emotional reaction. So what I tell clients to do is to, in the back of their head, keep thinking, how will my actions look in court? How will this be perceived by third parties? How will this be perceived by the judge? How will this be perceived by Children's Aid Society? And ultimately, will this help or will this hurt my case? So these are things that I like to communicate with clients um, when they get that bad news.
Those are some great tips, Joe, because like family law in general is emotional, but then when you're dealing with false allegations, then the response is, you know, it's more intense, and obviously no one wants to be on the receiving end of, if you feel like the other party is lying, then that's going to trigger some emotional responses. So being able to manage those as the first step is definitely the way to, handle this and then like make your way forward, either through yourself if you're self-rep or through your counsel as you strategize on how you're going to move your case forward.
100%.
But thank you for that. Moving further into our topic, let's talk about another key aspect, which is gathering evidence to disprove these claims. Joe kind of mentioned on that too. So as we've seen, having solid documentation can make a huge difference in family law cases. especially when you're dealing with false allegations. So when you are dealing with something like that, one of the most effective things that you can do is you can gather and you can organize evidence to disprove those claims. Documentation is absolute key. The court is not going to solely rely on one party's word against the other. They need to see facts, they need to see patterns, they need to see proof. And so, for example, if your ex claims that you've been verbally abusive or you're threatening them, then it might be a good idea to go back and review your communication history. If your messages show that you've been respectful, you've been consistent, then you save those. So you have those messages as evidence that you were not abusive verbally, you were not threatening. On the flip side, if their messages are aggressive or manipulative, then those can help establish a pattern that kind of contradicts what they're alleging. Um, if you're dealing with children, so let's say the allegation is that you're not involved in your children's life, then you might want to gather proof that shows your involvement. This could include things like maybe school emails, attendance at extracurricular events, photos, even maybe documents or some sort of evidence or emails from teachers or coaches or mutual friends. If you've been the one who's, initiating visits, you're the one who's following up about appointments, or you're the one who's trying to, co-parent, then you want to document these attempts, because this can discredit the other party, this can discredit their false allegation. We also quite often see claims about substance use. If you feel like that's false, then doing a drug test could be used to address that false allegation. There could be allegations about missed child support. If that's the case, then you can show your payment records, you can show your bank statements, you can show e-transfers. If Fro is involved, then you can get a statement of arrears from Fro that could kind of outline exactly what has been paid, what hasn't been paid. Even things like pickup logs or medical records or receipts for, the amount you spent on clothes or supplies. The keeping all of that can really go a long way in terms of proving your side, or maybe if you need to discredit the other side, then you can use these documents to do that. And it's not just about disproving a specific claim, it's also about, building a broader picture about credibility, because courts will take note when one party comes prepared with timelines, they have their story aligned, while the other party they're relying on vague narratives, shifting accusations, and so if you're the party who's coming prepared to the court date, then obviously that can work in your favor. Ultimately, the truth matters. In litigation, the truth is often um, dependent on your ability to prove it. So gathering and organizing your evidence is one of the best ways you can protect yourself, and refocus on matters that are important. Um, so Joe, coming back to you. When false allegations are made in family law cases, I think one of the most crucial steps is seeking legal guidance. Could you explain why consulting a lawyer at an early stage is critical in these cases, and maybe give some insight into what someone might expect speaking to a lawyer?
For sure. Just to just to go back and actually touch on what you mentioned. You mentioned that the evidence is key, and we tell our clients all the time that assertions only go so far. Assertions may be in the preliminary pleadings, whether that be an application. They may, if we're not in the litigation realm, these assertions to, again, like Children's Aid Society, they only go so far. And building up that repertoire of evidence to support your position is key. So rather than, again, as Shanta mentioned, tackling it, right away head first with no evidence, it's okay to take that time and build your case and build the evidence portfolio so you can attack it accordingly. But to get to your point with respects to consulting a lawyer, um, my advice, and I would say that majority, if not all of the lawyers at our firm would really tell you that legal guidance is not an option. It's not optional. Rather, it's essential from day one. And it's not in the sense that legal guidance is that, oh, you need to retain a lawyer, you need to have a lawyer on standby, but you should be seeking legal advice every step of the way, especially if you're not in a position to be able to afford legal counsel and you have to navigate the system as a self-represented litigant. That does not mean that legal guidance is not available to you. There's legal aid, there's the family law information centers, and these are resources that you should be actively using if unfortunately you don't have the resources to secure legal counsel, and that you are getting advice before you act. I would really stress that. Um, but let's just say, for example, there's a fresh accusation put forward. You're not in the legal process as of yet, which means there's no application that's been started. Maybe that you haven't even begun negotiations with respects to a separation agreement. This is extremely fresh. Um, Early intervention matters. Um, so the earlier you're able to speak to a lawyer and make them aware about the allegations, the more options you have to A, control the narrative, B, you have enough time to gather evidence, and C, you're able to protect yourself. So providing enough time to allow your lawyer to discuss a strategy and to provide you with these three options, it just serves a benefit, quite frankly. Um, Furthermore, it also, once you get wind of these accusations, being able to consult with your lawyer immediately on these issues, they can provide you interim protection as well as clarity on maybe the strength or likelihood of success based on their assertions. So your lawyer may actually advise you to file maybe your own motion. For example, it can be for parenting time, anything in relation to an urgent motion or an urgent case conference. Especially if you're a self-rep, you may get this advice from the Family Law Information Center or again legal aid, or even if even if you've retained a lawyer, right? Getting this interim protection and being advised of ways in which you can go about this interim protection could potentially neutralize any immediate fallout. Um, Another thing that's really important for people to know, especially if they are a self-represented litigant, is that unfortunately legal missteps are extremely costly. Um, one wrong move, for example, violating a temporary order or, improperly contacting your ex or not going about discussions with Children's Aid Society appropriately, this can have a real negative impact on your case and can set you back significantly, right? So a lawyer really helps you avoid those missteps. And, you're paying the cost up front for legal expertise and legal guidance, and it really does save you from the cost associated either, financially, criminally, in relation to your family law matter itself. It helps you really avoid those missteps. Again, support with documentation and evidence, building up that evidentiary repertoire. So your lawyer will instruct you on what to collect, on what is good evidence to collect versus what is bad evidence to collect, and maybe what would necessarily not be admissible if this was to be presented in court. So this can be texts, emails, call logs, like Shanza mentioned, bank statements if there's a dispute over child support or spousal support payments. They'll also tell you how to store this information and most importantly, when and if you should be presenting this information, right? And finally, there's um, a real disconnect with sometimes having to navigate with the Family Responsibility Office, dealing with Children's Aid Society, even the police. There's often a real disconnect about how the general public or self-represented litigants can go about doing so. So if there are third parties involved in your matter, again, whether that be the Family Responsibility Office, the police, maybe if there's been criminal charges laid, Children's Aid Society, if there's been welfare concerns, if there's children involved, your lawyer actually has the ability to ensure that you're not, again, making statements that could harm you, both criminally or civilly in your family law case. So it's really important before you take steps that, again, you're thinking strategically for the long term. You're asking those questions in the back of your head. Will this help or harm my case? So it's really important, again, if you don't have the funds or resources necessary to secure legal representation, there are free services out there, and you should be contacting these services and getting advice on your matter before you're making those steps.
Great insights, Joe. I think typically when we are dealing with false allegations, then we find ourselves dealing with cases that are high conflict, and naturally we find ourselves within the litigation realm. And so I think another big topic to hit on, especially as you are talking about the importance of retaining and, getting assistance from a lawyer or a professional, is a lot of people are going to have to deal with filing legal responses. And we also have a question coming about, the forms, different forms you have to kind of like deal with as you are going through litigation. So if false allegations have been made against you in court documents, such as an application or an affidavit or a motion to change, for example, it's important to respond formally through the proper legal channels. In Ontario, the family law rules require that you file a written response within specific timelines, and failing to do so can result in the court proceeding without your side of the story being heard completely. So, for example, if the false allegations that you're dealing with are in an application, then you need to file an answer form 10. And you also need to file a supporting affidavit, Form 35.1, if parenting is an issue. Your answer gives you the opportunity to deny the allegations. It gives you the opportunity to put your own narrative, and it gives you the opportunity to make your own claims. If you are dealing with a motion to change, then you're responding with a response to motion to change, Form 15B. Again, supported by an affidavit setting out your position and any evidence that you want the court to consider. So those can be attached as exhibits to your affidavit. This is your chance to clarify the false claims that are being made against you, and they can be in relation to any of the issues that you might be dealing with. Could be parenting, could be support, could be property issues. So let's say maybe your ex falsely alleges that you missed certain parenting time visits, or maybe they're saying that you're unfit to parent. That's very typical in family law cases. In your affidavit, you can attach texts or documents showing that you consistently tried to see the children, or that you offered alternative times and that you tried to negotiate on your end. You can also include, like if you're dealing with support, you can include receipts, stuff like that. In some cases, you may also consider maybe even bringing a cross motion if you need the court to make new or different orders that what were sought in the original order, such as maybe you might want to request parenting time in your cross motion, or you could be asking for support in your cross motion or asking for costs. The idea is the responding your responding materials. The whole idea is that you want the courts to hear your side in a structured and a credible way. Judges rely on these documents. They rely on the affidavit and documents that are properly filed with the court, because most typically prior to your case conference, that's what the judge will be reviewing. So if you're attending your case conference without filing your materials, the judge will not have a chance to listen to your side of the story. So typically, you want to make sure if you're not sure what forms you're dealing with, reach out to a lawyer. They can help, they can assist, but you do want to make sure that your side of the story is heard. Typically, in case conferences, if you do show up without your brief, you could even be facing a cost award. So you do want to make sure you are adequately prepared for your court date. Moving on, and Joe, if you want to say something, sure, but I also want to bring it back to you. And so in situations where false allegations are made, it's sometimes people are dealing with requesting court order evaluations, and that can be an effective way to clear your name. These professional assessments can provide an impartial view. Could you walk us through why it's important to consider these evaluations and how they can make a difference in a family law case?
Yeah, for sure. So with respects to court ordered evaluations, the bottom line is that you have two parties asserting their own version of the truth or what they perceive to be their version of the truth. And really at the end of the day, you have two viewpoints the judge doesn't necessarily know, on the basis who's telling the truth, who's not. But what they do know is that they can get objective professional assessments, and these objective professional assessments are able to refute false claims. And this is just, generally speaking, if maybe one party doesn't at their fingertips have the necessary evidence themselves to be able to refute a false claim or an allegation, they may need to rely on objective professional assessments to assist them in doing so. Um, so bottom line, why these evaluations matter. As I mentioned, these allegations often hinge really on perception. So psychological assessments, parenting assessments, voice of the child reports, all of these can offer neutral insights, which is extremely important because it doesn't form any bias from one side. And again, they're neutral, third-party, objective reports and pieces of evidence that the court can rely on. There's various types of evaluations that are often seen in family law. The first being a Section 30 assessment, and this is done in reference to the Ontario legislation. And a Section 30 assessment is conducted by psychologists or social workers, and what they do is they evaluate parenting capacity in family dynamics. So if maybe one person is making a claim about the other person's ability to parent, this would be something that the other parent who's having those allegations put forward against them would bring forward as a possible remedy or a possible way to get that additional evidence to refute those claims put forward. A Section 30 assessment is a privately funded assessment. It's not something that is covered publicly through taxpayer dollars and through the government. Unfortunately, this assessment is not necessarily within reach for lower, even sometimes to middle income brackets. These assessments can range between eight to upwards of $25,000, depending on the number of children and how in-depth these reports are. So again, this is publicly funded. Again, they're not always reachable to the average family law litigant. However, these do provide a means in which a party can get the necessary evidence. We also do have what's called a Section 112 assessment, and this is something that is publicly funded. However, this is run through the Office of the Children's Lawyer. So the Office of a Children's Lawyer is a government agency. However, the court, upon request to the OCL, the Office of the Children's Lawyer, the OCL doesn't accept, nor do they have to accept every request by the court to involve their services. Um, just given the influx and the amount of cases there are and number of matters that are in the court system, they don't have the necessary resources to respond to each and every request seeking their services. So there is a chance that the OCL may not accept the request despite the court's order or request to do so. However, if the request is accepted by the Office of the Children's Lawyer, um, there various assessments could happen within the matter itself. So more often than not, we see a voice of the child report. So when children are a mature enough age or mature enough in general, these reports are able to share the views and preferences of the children involved in the matter without direct parental interference. We also have the capability for the OCL to actually be involved as counsel for the children if it's a necessity and the OCL believes it's a necessity. And what happens in these cases is that the children involved in the family dispute actually retain their own counsel. So their counsel on the matter will put forward their clients, so to say, their views and preferences on the situation. And the OCL lawyers do have great influence in the sense that they're putting forward the children's views and preferences, and those should be taken with great attention to the judge when making decisions regarding parenting. We also have, and I mean, they are less common. However, more often than not, clients really request that we put forward these assessments and their psychological testing assessments. These are useful if mental health issues are part of the allegations. However, more often than not, it is difficult or I find, at least in my practice, I don't know about your practice, Shanta, you can speak on this, but more often than not, judges aren't necessarily willing to agree to these psychological testing assessments unless they're done on consent, which means both parties have to agree to it. More often than not, if there's a single party having these allegations with respects to mental health, I would basically advise clients that if they currently are seeing a medical professional, whether it be a psychiatrist, maybe they're seeing their family doctor regularly or a psychologist, I would tell them to get a letter from their health professional, basically outlining what they're seeing the doctor for or their family professional for, whether or not their mental health issue is being treated. And that provides pretty much a clear and concise landscape to potentially refute any mental health issues or concerns that are not being addressed or alleged to not being addressed. And what I'm getting at is that all of these assessments or all these types of evaluations, they help the judge really see through the noise, right? We have your materials, we have their materials. Everyone's sort of throwing word vomit on paper, saying he's doing this, she's doing this, and really these evaluations and assessments can are and very effectively dispel allegations. Um, so it's really important that you're getting objective evidence and not just putting forward assertions, because quite frankly, assertions by either side are not enough. And what I tell clients to do is that it's really important to be proactive and not reactive. So if you're confident that the truth is on your side, you should be able and willing to welcome scrutiny from third-party professionals, which means you should be agreeing to have these third parties, such as the Office of the Children's Lawyer, be involved in your matter, and to be able to want to put forward a voice of the child report. You should be able to going to your family professional or your mental health professional and getting a letter confirming that your mental health issues are being taken care of and that they don't pose a risk or safety to the well-being of the children. You should be proactive and you should not be waiting until it comes down to the point where we're at emotion and you don't have this evidence ready. You should have all of these pieces of objective evidence in front of you at the judge's fingertips. And also, you should be sharing this with opposing counsel or the other self-represented litigant if they don't have counsel, right? This disclosure should be happening periodically, and as soon as you get it, you should be sending it over to them to dispel any assertions they're making. And as always, it's really important to follow through on scheduling, paperwork, and interviews for any of the evaluations that have been set up. Um, More often than not, non-cooperation can be spun as guilt. That's just the unfortunate reality. So, I mean, even if you don't necessarily believe in the confidence of these evaluations, non-cooperation is really is of no benefit to you.
Thank you, Joe. That was very useful. I hope that you were able to provide a useful overview of some of the litigation aspects when it comes to addressing allegations. I guess, moving forward and tying what we talked about litigation to how, Joe, you mentioned earlier about, the emotional response when it comes to facing false allegations. And I think something that people might struggle with as they're dealing with these allegations as they are within the litigation process is the urge to make counter allegations. And sometimes this can make things worse. So when you are facing false allegations in a family law matter, like Joe said, it's natural to feel angry, it's natural to feel frustrated, but it's important to avoid retaliating or making emotional counter allegations, reacting impulsively, especially in writing or in court documents, can damage your credibility. And it may make it look like both parties are being unreasonable or engaging in a tit for tat behavior. In family courts, judges expect parties to remain focused on the issues. And especially when you're dealing with children, they want the parties to be focused on the best interest of the children when parenting is in dispute. If you respond to every false claim with an equally harsh or unfounded accusation, especially without clear evidence, that can weaken your position. The court may see it as an inability to cooperate, or worse, they see it as a high conflict behavior. For example, if your ex accuses you of being unreliable, and you respond by saying that no, they're the one who are mentally unstable, or they're the one who are alienating the child from you without proper evidence, then that's going to undermine your credibility. Instead, the better approach is to calmly present your side. Back up your story or your side by records, by evidence. Let the evidence speak for itself. And particularly in parenting matters, you want to demonstrate that you're the parent who's child focused and capable of facilitating a healthy relationship between the child and the other parent. That's the key part of the best interest analysis under the Ontario Children's Reform Act and the Divorce Act. If you come across as vengeful, it can raise concerns about your willingness to support the child's relationship with the other parent. So rather than retaliating, stick to the facts. Be respectful in your language. Show that you're willing to cooperate. Show that your primary concern is the children's well-being. You don't want to score points. You don't want to fight back. Um, and this goes a long way in showing the court that you are reasonable, you're a responsible parent who can put the child's needs first. Um, Speaking more on emotions, Joe, could you explain why it's so important to be mindful of what's communicated and how it might impact someone's case, especially when their emotions are running high as they're facing these false allegations?
Yeah, for sure. So, I mean, what I tell clients is that everything you say, written or spoken, can become evidence. Bottom line. So it's really important to avoid direct contact if tensions are high, and more often than not in family law, tensions are normally high, or the household environment is at a point where it's ready to explode. So what I advise clients is that right from the get-go, they should be, or at least consider, using parenting apps. Talking Parents is a great one. I believe it's free. Um, our Family Wizard is really good, but there's a fee associated with that. There's also App Close, which is a free app. And what these parenting apps are designed to do is to maintain a documented civil record of communication, or at least that's the idea. So if one parent is choosing to um, blast off over text message or email, that's that's their choice. That should not be reciprocated. Rather or not, you should be using these parenting apps, because what it does is it forces, and I mean it forces in the sense that all the chats are recorded. So it keeps a record of the communication. So it's a really great way to document the communication between the parents, and to keep keep both parents sort of in line, and it acts as almost as someone's observing when they're not really observing. So these are really great tools. Um, I always also tell clients that they should be speaking with the other parent. Um, and more often than not, they should never really be having, face-to-face conversations or conversations over the phone. Rather, I advise that all communication should be done in a written format that's traceable and has a record keeping of. So either again, text message or email. But they should be speaking with the assumption that your words would be submitted in court. So it's really important that any communication you have to the other side, to your ex spouse, um, you should have that assumption that what you're writing could be used in court. So you should be acting accordingly. I also really tell clients that it's really important that they stick to neutral, factual language. Engaging in emotional tones is never a benefit to you, and it's never a benefit to helping resolve the situation or trying to dial down tensions. So, for example, um, instead of saying you're lying, you're ruining my life, you're ruining the children's life, you could say, I disagree with your version of events. I disagree with the assertions that you're putting forward. I'm prepared to address this appropriately. I'm prepared to address this through alternative dispute resolution means. Prepared to address this through mediation. So you want to show that you're engaging in child-focused communication. And to that end, don't try to win over text. I see oftentimes communication is you're trying, or one parent is trying to get the other parent to admit to something that they've done in the past, or they're trying to backtrack in writing, right? They're trying to backtrack. Oh, well, what did you say to me yesterday about not wanting to be involved or not take, Timmy to hockey practice because you're too busy? Like, don't try to win over text message. It more often than not leads to more trouble. Rather, what you should be doing if you're seeing this pattern of behavior from a parent, for example, relation to parenting time, for example, or the ability or capacity to parent, you should just be documenting the actions that are transpiring and preserving that evidence. Um, what I like to tell clients too is that if they receive a threatening or inflammatory message, again, resist the urge to respond immediately. I always tell clients the 24-hour rule is great. So if you get a message that, again, is threatening or inflammatory, there's no gun to your head. There's no need to respond right away. More often than not, it's not something that's urgent that requires a response. I tell clients, sit on it for 24 hours, allow you to calm down, and that allows you to put forward a reasonable child-focused response. And it also allows you to share the message that you received with your lawyer if you have one, and they can provide guidance, right? There's no benefit to responding quickly and hastily. And again, you should always be having the little guy on your shoulder or the little guy in the back of your head saying, will this help or hurt my case? I need that to be crystal clear to everyone. All of your actions, you know, should come with the premise of you having the foresight and be able to have this conversation with yourself is in the way in which I am responding is beneficial, right? Um, and last but not least, do not post on social media. Don't post on Instagram. Don't post on Facebook. Any public forums, right? Public posts can be screenshotted and they can use to demonstrate hostility or poor judgment. Even if the post isn't directly about your spouse, you should not be posting on social media. Number one, I wouldn't suggest getting other people in your lives involved in this. I mean, more often than not, these are private matters, and they should stay private for yourself and for your children, if there are children involved. Family members are one thing, but that should be done in a private setting, not on a public forum. And two, what gets posted on the internet is there forever, even if you delete it. So there's ways in which those posts can be collected. More often than not, sometimes a screenshot happens before you realize the mistake you made and you're able to delete it. So at the end of the day, again, you should be making decisions with the outset or with the thought that anything that you've done, again, written or spoken, can be used and become evidence. So you should really be mindful of this.
Thank you, Joe. Those are some great pointers. I know some of our audience might be thinking easier said, but practice makes perfect. You can do this.
But the 24-hour rule is amazing. I mean,
Yeah.
it's used in so many contexts. Um, and just I promise if you take, a day to gain your thoughts, like again, jot down your position, write it down, share with your lawyer. I can promise you that you will be able to 24 hours later put forward a more reasonable child-focused response that is going to be of your benefit.
100%. And I know everything that Joe talked about is emotionally and mentally taxing on our clients, which is why it's important to seek support during this challenging time. Um, so remember that you don't have to go through this alone. You don't have to go through your family matter all by yourself. Talking to a counselor, a therapist, or a trusted friend can provide you with an outlet to express your feelings. It can reduce the emotional burden on you. A counselor, for example, can help you manage your stress. They can help you process your feelings of anger, frustration, sadness, anything that might arise from your family law case, and from the allegations that you might be facing from the other side. Having an emotional support also allows you to approach the case with a clear head, kind of hinting to the 24-hour rest period that Joe mentioned, rather than letting your emotions cloud your judgment or decision making. Sometimes when we are under pressure, or if you're feeling hurt, then it's easy to react impulsively. But by, taking your time, by talking things out with a professional or even a friend, you can get perspective on the situation and you can be reminded of your long-term goals. Which should always be the focus should always be on resolving the matters. If there are children, then the focus should always be their best interest. And if you are like speaking to a professional, that can really help you because they can teach you strategies for managing conflict. They can teach you strategies for improving your communication. Um, and they can teach you strategies on how to deal with basically co-parenting challenges that can arise, that may currently, uh, be there or that may arise in the future. Um, if you're dealing with allegations about your parenting abilities, then maybe speaking to a counselor or getting support and staying grounded and objective while you make your way through this can really benefit you. And it can also benefit your relationship with your children as you learn to manage your emotions better. Again, you can lean on your friends, you can lean on your family members. They're going to be supportive of you. They can offer you advice. They can be there. They can just be there to listen. Even if they're not able to provide you with legal advice, having a support system can really remind you that you're not alone. You're not defined by the accusations that are coming from the other side. Um, really having that support system can really give you the understanding and the care that you might be looking for as you make your way through your family case. Again, bottom line, seek support. If you're struggling, speak to a professional, speak to a friend, speak to a family member. Their support system can really help you stay focused. It can help you stay calm. It can help you stay clear-headed, which is essential when you are making your way through the family, court system. It ensures that you can approach the legal process with confidence, knowing that you have the emotional strength to handle whatever comes your way. Now, kind of shifting back our focus to litigation, Joe, what's the role of maybe involving third parties or witnesses when it comes to these allegations? Why is it important to have testimony from, third parties, and how can that make your case more effective?
Yeah, so again, it comes back to objectivity, right? You have two sides putting forward assertions, um, and maybe without this objective evidence, you don't necessarily have a leg to stand on, or you don't have enough evidence yourself to support your position, and you require objective third-party evidence. And bottom line, witnesses offer credibility. Judges rely and more often than or at least consistently rely on third-party accounts to determine truth. And this is especially the case if there's he said, she said scenarios. The typical third parties that are relied on, of course, is the Office of the Children's Lawyer if they're involved, whether that be the lawyers themselves or if there's clinicians or social workers assigned to the file. Um, but not only that, there's other types of witnesses to consider to help bolster your evidentiary portfolio when you're trying to put forward your position. The first being professionals, and I've mentioned this already. So it can be doctors, therapists, teachers, daycare providers, anyone who can speak to your behavior and stability if that's something in question. Um, Friends and family members, I mean, they're not the ideal witness, More often than not, I find friends and family members to be biased, and the judge will take less weight to those individuals. But I mean, if it's a family member who's a mutual family member, so for example, if you have um, for example, two spouses, maybe your spouse's parents, if they're able to give you beneficial information or are willing to sign an affidavit or willing to be a witness at a trial, well, they don't have to necessarily be willing to be a witness at the trial. You can summons them. But I mean, if they're willing to put forward an affidavit, for example, at a motion, um, that's obviously more beneficial than having maybe your own brother or your own sister or your own parents giving affidavit evidence. Again, it just all comes back down to credibility and whether or not there's a bias or a perceived bias. And sometimes too, I see more often than not people get letters or affidavit evidence from supervisors or colleagues in the workplace who can speak to your credibility, your character, any absence of concerning behavior. Again, these things sometimes sort of spew a bias. More often than not, I really like affidavit evidence from professionals. I think it's provides a more objective means in putting forward evidence. Again, doctors, therapists, teachers, these are people who are professionals. They have a reputation to abide by, and they're less likely to be seen as being biased. Um, with respects to actually getting this affidavit evidence, for example, if it's ahead of a motion that you're attending, it's really important to ask these witnesses who are willing to put forward affidavit evidence, um, that they document what they've seen, and again, ideally an affidavit form with dates and specific incidents, excuse me. You want to be as specific as possible in these affidavits because the clearer you are, the more credibility these witnesses can offer. Um, Sometimes if a witness cannot formally uh, testify in the sense that they don't want to put forward affidavit evidence, um, sometimes it's good if they want to, keep a journal of what they've witnessed. These can also help build your cases. I mean, it would be not direct evidence, but these are things that you can use as well. And if you are on the trial path and you have a trial coming and they are going to be your witness at trial, you're going to be summoning them to trial as a witness. You're going to have to prepare them for court, right? So let your lawyer know early on who you plan to rely on, so that they can prepare these individuals again if the matter actually progresses to trial. I mean, at the end of the day, only about 3% of family law cases proceed to trial. The system is really geared towards settlement, and that's predominantly due to the number of conferences we have from the date the application is filed until a trial. We have several conferences. The family law system does not want to see family cases go to trial. They heavily promote settlement. But I mean, there are cases that don't settle. There are cases that do have to go to trial. And if you want to have these witnesses put forward either affidavit evidence in court, or maybe they'd be speaking viva voce, so in person they're speaking, um, you're gonna have to prepare them. So that's what I can say to that.
Thank you so much, Joe. We only have well, we are going towards the end, so I just wanted to give everyone a bit of a conclusion on what we talked about today and maybe some advice on staying focused on the bigger picture before we let everyone go. So I know it's easy to feel overwhelmed by emotions and frustration when it comes to defending yourself in the family courts. However, it's important that you stay focused on the bigger picture, which is resolving the situation legally, efficiently, and with the least amount of disruption to your life. Family law issues can be very complex, and whether you are dealing with a matter of parenting time, you might be dealing with support, you might be dealing with property division or equalization, or even spousal support. Your long-term goal should be able to reach a fair and reasonable solution that minimizes the emotional and financial costs for you and your family. Getting caught up in allegations, counter allegations, or your desire to prove your ex wrong, or the desire to address every allegation or everything that they said in their materials could be a strong urge, but that can also lead to draining you financially and emotionally. So if your ex is accusing you of financial misconduct or hiding assets, it might be tempting to immediately engage in a heated back and forth to defend yourself. But take a step back, focus on, like we said before, presenting evidence such as financial records, maybe your tax returns, any relevant financial documents that will provide a clearer path forward, rather than becoming entangled in the emotional aspect of these false allegations. Focus on the legal and the factual aspects that will allow you to move the case forward in a more productive way. Similarly, when it comes to children, even like child support and spousal support, instead of getting stuck on false allegations about your ability to meet your financial obligations, focus on showing the court your true financial situation. A lot of times we see cases where there's a imputation of income at issue. And so your focus should not be, retaliating on every aspect that's been put forward. What you want to focus on is to be able to provide your true financial situation to the judge, providing your pay stubs, your tax documents, your budget. All of that can demonstrate your capacity or your limitations, and it can help maintain a professional and efficient approach to resolving any issue of support. Um, the more you engage in unnecessary conflict, the longer and more costly this process will become for you. This will increase legal fees. It's going to delay resolution. Like Joe said, the system is designed where, settlement is at the top. So you do want to focus on that, especially if children or your financial stability are on the line. It's far more beneficial to um, engage in negotiations than litigating your case towards the very end, where you make your way to a trial. In the end, while defending yourself is important, so you do want to find that balance. You do want to defend yourself from false allegations, but you do want to remember that the bigger picture here is always moving forward, finding resolution, and protecting your rights. And the best way to do this is to stay focused on the legal aspects of your case, use your resources efficiently, avoid getting bogged down in a prolonged dispute that may only harm your position in the long run. Okay, well, thank you so much, Joe, for joining us. It's 5:57, so we're almost at the end. Thank you to our audience for joining in today. Following this session, a brief survey will appear, which will allow you to share your comments and suggestions for future topics that you would like us to explore. Your feedback is greatly appreciated. You can also book your complimentary consultation with one of our lawyers. You can contact our intake team at intake@russellalexander.com, and you can provide them with the code Spring 2025 to schedule your appointment. I know you said you saw some flurries earlier, Joe, but I'm going to be optimistic. It's going to be spring soon. It's going to be warm weather. But thank you everyone for joining in today. And thank you, Joe, once again for all your
Thanks,
insight.
everyone. Thanks,
Okay,
Shanza.
bye now.